Good morning. This webinar offers closed captioning. To enable closed captioning, click on the live transcript button on the bottom of your screen and choose your preferred method. Welcome to the Chicago Department of Business Affairs and Consumer Protection. Please note any website or email that I mentioned will be posted in the chat box. For those seeking business licensing assistance, you can visit the Small Business Center at City Hall or call 312-74-GO-BIZ. Also, business licenses can be applied for or renewed online at chicagobusinessdirect.org. If you are part of the BACP Entrepreneur Certificate Program, you can get credit for joining this webinar by sending an email to bacpoutreach@cityofchicago.org. If you want to learn about the program, please visit chicago.gov/businesseducation. Also, this webinar is being recorded and will be available at youtube.com/ChicagoBACP. I will post the mentioned information in the chat box. We encourage attendees to ask questions. Please use the chat box to send your questions. There will be a Q&A session at the end of the presentation. Please note that the views, information, and opinions expressed during this webinar are solely those of the presenter and do not necessarily represent the official policy or position of the Department of Business Affairs and Consumer Protection or the City of Chicago. Today's webinar will be When to Set Up an Entity and Entity Choices, presented by Darren Green by the Donald Pritzker Entrepreneur Law Center, Northwestern Pritzker School of Law. Darren?
Thank you, and hello everyone. It's great to be here. We always love these presentations and sharing whatever we can that may be helpful to entrepreneurs during those early tricky stages and kind of launching and growing a business. So I'll sort of start by introducing myself a little bit, and then we'll sort of dig in. As Joan mentioned, I love questions, and so please do post them in the chat throughout the talk. I'm going to save 15 minutes at the end to have a look at the questions and answer everything that I can. So again, my name is Darren Green. I'm on the faculty at Northwestern Law School at the Donald Pritzker Entrepreneurship Law Center. We teach classes in contracts and entrepreneurship and investment and all sorts of other topics. So we love working with entrepreneurs and kind of in this space. And I've been doing that for many years. So with that said, let's dig in. What we're going to be talking about this morning is a topic which maybe isn't top of mind for most folks that are starting a business. There's all sorts of things you think about when you're starting a business. What you're going to be doing, how you're going to get customers, all of those good things. But there are some things on the legal side that while they may not be as interesting to you, they're quite important to help your business grow and to sort of help protect you as you hopefully grow your business. And one of the most important things is forming an entity of some sort, getting the right structure in place at the beginning, at the front end, to help you sort of achieve your goals. And that's going to be the focus of our talk this morning. So let's start at the very top. Let's start with the why question. Why do we need to form an entity in the first place? You don't have to form an entity. There's no law that requires you to form an entity. You can operate a business by yourself if you start a business. You can be what they call a sole proprietor. And some folks do that. But there are some good reasons to think about forming an entity, and let's talk about those. One of the main reasons that we see founders and entrepreneurs form businesses is to sort of protect against liability, right? So as I'm sure most of you know, sometimes things go wrong with our businesses. Sometimes the folks we do business with maybe feel we did something wrong. They're unhappy with the service or whatever the case may be. And they might sue, right? They might initiate a lawsuit. That happens a lot in the United States these days. And we want to make sure as an individual that we're protected. We don't want them suing us as a person and going after things that we may own as a person. We want to build a shield, a sort of a moat around ourselves so that anyone who's unhappy with us can only sue the business. They can't go beyond the business and sue me as a person. And the best way to do that, and the principal way to do that, is to form an entity, right? When we form a corporation or a limited liability company, now, so long as we take the right steps to act like a corporation or a limited liability company, that person who's upset with us, that business partner, whoever it is, they can only sue the entity, and that's the end of it. So establishing that liability protection can be important. And the earlier we build the entity, form the entity around us, the less risk we have of a lawyer suing us personally. So that's one of the main reasons. And we'll come back to this liability concern in a few minutes, because it sort of comes into play in other aspects of thinking about entities. So liability protection is number one. The second reason we want to think about forming an entity is businesses are not always just one person, right? Oftentimes we've got co-founders, multiple folks that are starting a business together. Matter of fact, that's very common. So in order to do that, if we don't form an entity, we haven't established any of sort of the ground rules. How do we relate to one another? How are decisions going to be made if we've got 3 of us or 4 of us forming a business together as co-founders? If we haven't established an entity, it's very hard to sort of lay out the rules of engagement. Who gets to make decisions? Is it majority carries the day? Is there one of the 4 of us that gets to make decisions? Who owns what, right? So do we all own, if there's 4 of us, do we all own 25% of the business? Often there might be one founder, maybe if it was their idea, maybe they own more than the other co-founders. Well, we need an entity to sort of slice up that initial pie. When you think about entities and the equity that you're going to issue as a pie, we sort of slice that up among the initial owners. And to do that, we need an entity. If there's no entity, there's nothing to slice up. It's just 4 of us operating a business. So sort of locking down the deal among the co-founders so that everyone's expectations are sort of pointed in the same direction. We know what each other own. We know how decisions are going to be made. What if one of us decides we want to sell our interest in this business to some sort kind of a third party? How do we deal with that? Are we comfortable allowing one of the founders to sell to a third party? Are we not comfortable? All of that, all of those decisions are sort of detailed within the documents that you draft when you create an entity. So you've got to have the entity to have all of those founder type agreements, those shareholder type agreements, which make sure that we're sort of set up so we know how things are going to run. So liability protection is number one, right? Building that shield around ourselves so we're not going to be personally liable. Second reason is to sort of help us establish the deal among the co-founders. There's many reasons to form an entity. A third reason is sort of related to the second one. As many of you know, or as all of you know, businesses take money to run. They take investment. Sometimes we make our own investment into our businesses. They call that bootstrapping, right? Where we take our own dollars and we drop them into the entity, into the new business so that the business has the money it needs to hire people or to perform marketing, to build its website, whatever you're doing for your business. But sometimes we look to the outside world for money, right? We look to the outside world for investment. And if we're ever going to get an investor in our business, the investor is going to give us money, and that's great, but we need to have something to give to that investor. And when you think about what investors are typically looking for in return for their money, they're looking for an ownership stake in the business, shares of stock if it's a corporation, or membership interests, as they're called within a limited liability company. That's what they get. So they give money and they get an ownership piece in the business. Well, in order to give those investors an ownership stake, we have to have something to give them. If I don't have an entity, I've got nothing to give to the investors. It's just me. I'm not going to give them my arm in return for the investment. I need shares of stock or membership interests. In order to do that, I need the entity. And any investor in an early stage business or an entrepreneurial venture is going to expect to see that entity early on, because then they're going to know that they can buy something in that business. So that's yet a third reason to form an entity. Investment, so liability protection, establishing sort of the deal among the founders, and having something to sell to investors, a little piece of our business to give to those investors that are going to give us the money that we're going to need to grow our business. There's all sorts of other reasons that we won't go into here. There's tax reasons. Lawyers like myself tend to get nervous when the word taxes is mentioned. We run the other direction. But it's important to know at least that there are tax considerations, and having an entity in place can help entrepreneurs sometimes reduce their tax bill. Entities allow for certain strategies to minimize taxes, and you'd work with your accountant to figure out what those are. But suffice it to say, without the entity, you may not be able to take advantage of certain tax breaks or tax savings that you can when you do form an entity. So that's yet a fourth reason. We won't go into all the others. Hopefully that's enough to sort of convince you that there's some good reasons to form an entity. So that's why. That's the why we think about forming an entity when we're running a business. So let's move on from the why to the when. Sometimes this is even a trickier decision for founders. Most entrepreneurs sort of know, they've read something, maybe they've been involved with businesses before. They sort of know they need an entity to run their business. So that part of it, usually they can sort of check that box. But when to form the entity tends to become a little trickier. We in the Donald Pritzker Entrepreneurship Law Center will work with founders often who will say something like the following to us. They'll say, yeah, I know we need an entity, but we're really early in the process. We don't know if our business is going to sort of quote unquote get legs, as they say, right? Kind of establish itself and start to grow. It's a new idea. Maybe it's not going to work out. So we want to wait, right? We know we need an entity, but that sounds complicated. It sounds confusing. And we might even need to work with a lawyer at that stage. And lawyers cost money. We'd rather spend our money on other things. So we're going to wait to see if the business takes off. And if it does take off, then we'll do these things later. We'll form this entity later when we know we need that entity. So we certainly understand that in most entrepreneurial ventures, most startup businesses, dollars are tight, right? Most businesses don't start with lots of money. They want to earn that money, right, over time. But you've got to figure out how to sort of allocate this scarce resource, these dollars. And forming an entity doesn't seem like a satisfying way, or maybe the best way to spend money. And what we usually tell the entrepreneurs is we certainly understand, and that all makes sense, but it's still important to think about doing this, forming an entity as early as possible. And there's a number of reasons. There's a number of reasons for that. One of them, if it's just you, the reason I'm about to mention isn't as important. If you're a kind of a solo founder, a single owner business, then this reason won't matter as much. But if you have multiple owners, again, going back to co-founders, we mentioned establishing that deal. That was one of the reasons we want to form an entity. That's one of the whys of why we create an entity, establishing the rules among the owners. Well, if we decide to wait and we don't establish those rules, it may seem like we can do that later. The four of us who are starting a business, we really like each other. We all work well together. So what's the difference? If we do it now or we do it 10 months from now, who really cares? We'll establish the rules when we know we've got a real viable business. Problem is, things change over time. And if you've got other founders with you, other folks that are starting the business with you, you may be getting along famously early on. Things may be going really well. 10 months from now, things may have changed. And agreements that would have been easier to put together may be more challenging. Maybe there's sort of a dispute among two of the co-founders that's sort of arisen over that 10-month period. Maybe things are going really well, and one of the co-founders now feels that they should be entitled to a bigger ownership stake in the business. Yeah, maybe 10 months ago, 10% seemed reasonable, a 10% ownership stake, but now they've done a really good job over the past 10 months. and they feel like it should be 20%, not 10%. The other co-founders may not agree with that co-founder. They may think that original 10% deal was still valid, and that's the way it should remain. So agreements can get tricky, whereas it's never all that easy to put these agreements in place because it requires a lot of conversation and thinking about things which sometimes aren't so pleasant to think about. But it usually gets harder, not easier, if you wait. So waiting to form an entity until later, it may save us a few dollars on the front end by not having to sort of pay filing fees and work with a lawyer. It may result in significant disagreements down the road among the founders. And it may make it difficult, if not impossible, to come to agreement around these terms and these provisions, whereas it would have been easier early on. So that's one reason we think about doing it earlier rather than later. But there's yet maybe even a more important reason than that. We talked about liability, right? Nobody wants to be personally liable. Nobody wants to risk, if you have a car, you don't want to risk having your car taken by a creditor of your business. We talked about forming an entity to build that shield around ourselves. Well, if we operate for 10 months or a year, sort of during those early stages without an entity, right? We decide we're going to sort of see what happens, and then we'll form that entity when we need it. We haven't built that liability shield around ourselves. So for that 10-month period, we're exposed. Anything we do as a business, if it doesn't go well, and things don't always go well, and there's going to be a lawsuit, well, that lawsuit's going to be against us personally. So we've created this like stub period where we're exposed and we're at risk to getting sued personally. But it's actually even worse than that. When there's a group of co-founders, 2, 3, 4, whatever the number is as soon as it's more than one, and you're sort of operating together in a commercial manner, right, for business purposes, sometimes an entity is actually created for you. So even if you don't create an entity, the state in which you're operating will sometimes sort of look at what you're doing, and an entity will be automatically created. You won't even know that this entity was created because nobody tells you about it. Nobody rings a bell and says, hey, an entity was just created. You're not filing a document with the Secretary of State to create the entity. We'll get to that in a minute. That's what you typically do when you want to form an entity, sort of voluntarily. The type of entity which is formed automatically, without us even knowing, is called a general partnership. General partnership is kind of a dirty word, or dirty words in the world of entities. And the reason is nobody really wants to be a general partnership anymore, and maybe nobody ever really wanted to be a general partnership. The reason for that is that general partnerships don't provide the liability protection that we were seeking. In general partnerships, all of the owners of the business, that are called general partners rather than like stockholders in a corporation, all of the owners are personally liable for the debts and the liabilities of the business. But it gets even worse than that. You're not only liable for what you do in a general partnership, you as an individual are also liable for all of the things that the other general partners do. So if there's 4 of you, and one of you, let's say, is sort of a rogue general partner, you're off doing, this general partner's off doing bad things, entering into agreements that the other 3 didn't know about, taking on obligations that are not appropriate for the business on behalf of the business. You might not even know that this other co-founder was performing these bad acts. It doesn't matter if you knew about it. If you're a general partnership, you're responsible. You could be sued as an individual for the things that that other general partner did. So when a general partnership is formed, and again, no one tells you when it's formed, you're not liable for what you do personally, for what your business does, you're personally liable, and you're liable for what the other individuals, your co-founders, do. So that's a bad situation. That's the opposite of why we want to create entities. You're actually expanding your exposure and your risk rather than limiting your exposure and your risk. So we don't like when general partnerships are formed. Well, how do we avoid this automatic creation of a general partnership around our business? The best way, the safest way, is to form an entity ourselves. If we form an entity, the state in which we're operating will see, oh, that's a corporation, or that's a limited liability company. They formed an entity. They'll no longer form an entity for you because you did it yourself. You sort of got ahead of the state and formed it yourself. States don't form entities when you've already formed one for yourself. They do it when you don't form an entity. And the problem is, if you wait to form your entity until down the road, a general partnership may arise in the state in which you're operating. I'm using 10 months as an example. Let's say you wanted to wait 10 months to form your entity. There's a good chance during that 10 months, a general partnership was created. And if a general partnership was created, there's all sorts of liability risk during those early stages that will stick with you even after you form your entity. So forming an entity early on avoids that risk, the risk of the general partner being formed, the general partnership being formed. I mentioned you won't even know if a general partnership is formed because nobody tells you. You may know at some point, and maybe you've already, maybe you all suspect this already or figured it out. The point at which you know that a general partnership was formed is often when you're in court, right? So if the business gets sued and some plaintiff, somebody who feels that you've done something wrong to them, is suing the business, their lawyer, if they catch wind of the fact that you operated as a business without an entity for all of this time, they're going to maybe sue each of the owners personally and argue, hey, this was a general partnership for a while. They should all have personal liability. Well, the judge will then look at these arguments, and it'll be the judge that goes back and says, yeah, you know what? This was a general partnership. On June 10th, 2022, they didn't have an entity, but they were operating together for sort of commercial purposes. That was a general partnership. So you'll learn this bad thing after the fact when you're in court, when a judge looks back and says, yeah, that was a general partnership. That's a bad time to learn you had a general partnership, right? That's a little bit too late in the game because now you're personally liable. So what we will tell entrepreneurs generally is earlier is better than later. It doesn't cost all that much to form an entity. A lot of founders have a fear that it's going to cost many, many thousands of dollars. And there's ways to do it where you can sort of limit what you spend early on, sort of keep things simple. And you can avoid all of these risks of waiting. Now, if you're an individual running a business, so you don't have any co-founders, it's just you, the risk of a general partnership is less because you're not operating with anyone else. So in that situation, if it's just you operating your entrepreneurial venture, yeah, maybe then you could wait a few months. At that point, you might say, I want to see if I've got a viable business. I want to see if we're going to grow, and then I'll form the entity. You still do take a risk as an individual that you're going to be sued personally if something bad happens. And so you'd have to take that risk with your eyes open and understand that you're taking that risk. But if you don't have any co-founders, at least you're not taking the general partnership risk where you become liable for all of their actions as well. So as a sole proprietor, an individual running a business, maybe you wait. Still a little better to form it early, again, to protect yourself from a liability perspective. But as a group, usually not a good idea to wait. You want to do it earlier rather than later. So we've talked about why we form entities, the liability protection, establishing rules among the founders, taking on investment, potential tax savings. We've talked about when. Earlier is generally better than later, with limited exception. We want to, as soon as we know we've got a business, a viable business, we're going to be operating a business, let's form that entity. I want to spend a few minutes on how we form an entity, because sort of demystifying this can sometimes reduce the fear level that founders have about forming one of these things. And we'll talk about the choice of entity in a minute, which entity may be more appropriate. But whatever you choose, a corporation, an S corporation, a C corporation, a limited liability company, these are all very popular choices. The process is typically pretty simple. There's a filing usually. The filing is usually a page, maybe a page and a half, it's short. Usually you only have to provide a few pieces of information. You don't have to provide that much information. And you file this document with the Secretary of State in the state in which you're going to form. We'll talk about that in a minute. And you usually pay a fee. The fee usually ranges from $100 to $300, depending on where you're forming and what you're forming. And that's it. For corporations, what you're filing is either the Articles of Incorporation or Certificate of Incorporation. These documents are available online. Any state in which you're going to form, Illinois included, all of these forms are available at the Secretary of State website. And they're very simple forms. They want to know who's running the business. Sometimes they want to know who owns the business. They want to know the name of your business. They want to know your registered agent. That's just the individual that's going to sort of communicate with the Secretary of State. It's all things you'll know about your business. And so you fill out the Articles of Incorporation or Certificate of Incorporation. Or if you're going to be a limited liability company, they call it a Certificate of Formation or Articles of Organization. The name doesn't matter. It's a very simple document. You file it with the Secretary of State. These days, you can do these filings online. 10 years ago, 15 years ago, you would print out a copy of one of these filings. You'd fill it out either by hand or type it in on your computer, and then you'd submit it by mail or you'd walk it into the Secretary of State. These days, you typically don't have to do that. You can do it right from your computer. It may take you no more than 30 minutes to complete the form and file it. You can pay your filing fee online, and you'll get a stamped copy back of what you filed, typically online, that you can download and save on your computer. And that's it. That you've got your entity. Couple $100, half an hour, maybe an hour of your time to sort of think through some of the questions they ask you. That the thought that, well, I don't want to spend all the time and money right now forming an entity, it's not all that much time. And it's the fees in Illinois have actually come down. Illinois used to be more expensive to form an entity. It's now a lot less expensive to form an entity in Illinois if this is where you're going to be operating. So if you're in Illinois, you can file online. It's quick. It's very efficient. The Secretary of State website is very easy to use as it relates to creating entities. And it's pretty inexpensive in Illinois. Illinois has become one of the less expensive states to form an entity. So have no fear if you need an entity. It can be done pretty quickly. Now, there are other documents that we talked about sort of at the beginning of this talk when you've got multiple founders, right? Those founder agreements, the shareholder agreements that you're going to sign to establish the rules between and among the owners of the business. Those are a little more complicated. Those aren't available on Secretary of State websites because they're not state filings. Those are agreements that the owners of the business will sign and you'll keep in your own files. You may want to work with a lawyer, but there's plenty of lawyers that work with startup businesses and can sort of limit their fees. These days, we see lots of startup lawyers offer packages to help you with some of those other documents where it's like a flat fee. And for that flat fee, you'll get thing A, B, C, and D, which are kind of the things you need between and among the owners. So establishing the entity with the state, actually forming the entity and getting that liability shield quick and inexpensive. The other documents that we talked about that you're probably going to want if you've got multiple founders, a little more complicated, but you can still keep it relatively simple during those early stages and sort of minimize the amount you spend on those documents. So I mentioned the state of Illinois is a very efficient state to create an entity. I do want to mention that you can create an entity in any state. All 50 states will allow you to create an entity. All 50 states have their own body of law, their own statutes that they have on their books, which sort of govern and describe how we form entities in that state, how entities run when they're formed in that state. So what state should you form in? There's no right or wrong answer to this question. You can form in any state. I'll tell you this, if you're based in Illinois and if you've got co-founders, other folks starting the business with you, if you're all in Illinois, there's usually not a great reason to form outside of Illinois. If you're all here, Illinois' laws around forming entities are perfectly adequate. They're very reasonable statutes and laws. As I mentioned to you, it's not expensive to form in Illinois. And as I also mentioned to you, it's fairly easy to form in Illinois. You can do it all online these days. Illinois has got a great website, the Secretary of State. So if you're all here, it's generally a good idea to form in Illinois. But let's say you're not here. Let's say you're opening your business in Indiana, or you're opening your business in some other state, or you've got owners that are spread out across multiple states. These days, virtual workplaces have become much more popular. Folks are working from all over the place. So maybe everyone's based all over the place. In those cases, you'll often hear the state Delaware mentioned, which is unusual. It's a small state. Not many businesses are actually based from an operations standpoint in Delaware, but Delaware many years ago created a very favorable body of law for folks that are starting businesses. A century ago, they did this. And because of that, lots of businesses have formed in Delaware. And so there's like a comfort level with the state of Delaware. It's kind of the fallback state. So if Illinois didn't make sense for you, if you weren't based here, you were in a different state, then you might think about Delaware, and you can do things online in Delaware as well. I'll tell you that Illinois' process, the Secretary of State intake process to form entities, is easier in Illinois than it is in Delaware. But Delaware would maybe be another state if everybody was spread out. It sometimes is like the compromise state to form in. But for most businesses, if you're here, if you're in Illinois, Illinois is a reasonable state to form in. So we've talked about why form an entity. We've talked about when to form an entity early. How we form an entity, again, it's very easy. Simple filing with the Secretary of State in the state in which we're going to form. And we've talked about where to form an entity. Again, for Illinois-based businesses, Illinois is probably a reasonable choice. But this leaves one sort of critical question that we get asked all the time. There's also no right answer to this question, frustratingly. There's never right answers to any of these questions. But the more information we have, we can make these decisions sort of on a rational basis that sort of works best for our situation. And that question is, what type of entity should we be? And the answer to this question has changed over the years. If we were talking about this 20 years ago, we might have had a different answer. There's lots of types of entities, and these days there's an ever-growing list of choices for entity selection. But we're going to focus on the most popular, sort of the greatest hits, if you will, of entity creation. And what are those types of entities? Well, one is a corporation. I've mentioned corporations at various points in this talk so far. The other is limited liability companies, or LLCs for short. That's another very popular choice. I mentioned general partnerships. That's a bad, we thumbs down to general partnerships. That's a bad choice. We don't like those for the reasons we talked about. That's the form the state creates for us, and we don't like that. There are limited partnerships, which is a different type of partnership. Those used to be a little more popular, but they've sort of been replaced by the limited liability company for various reasons. So we won't talk much about limited partnerships because they're pretty rare these days. You don't see many limited partnerships out there, other than for certain types of businesses where we see more of them. So let's talk about the popular choices. I'll start with corporations. So the corporation form, the corporate form, is really one of the oldest forms. When you go back in the United States to the very beginning, when secretaries of states were formed, and the state started to allow the creation of entities in those states, the corporation was there pretty much from the beginning. Many of the biggest companies, when you think about Google and Facebook, which I guess now is Meta, I'm not big on social media, as you can probably tell, but all these these massive companies, most of them are corporations, sort of going way back. So what are the benefits of a corporation? There's many of them. So one is, with a corporation, you get that liability shield that we talked about right at the beginning of our talk. Corporations are good at protecting those involved with the corporation, the owners of the corporation, the shareholders, and those that work for the corporation from liability. If a corporation gets in some trouble, or a third party thinks that the corporation did something wrong and they decide to sue, they can only sue the corporation and go after the corporation's assets, the corporation's money. They can't go after the shares, subject to limited exceptions. We won't get too deeply into those exceptions, but by and large, corporations will protect the owners. They put that nice liability shield around them, and third parties can only go after the corporation, not the owners. Corporations have some other benefits as well. There's no restrictions on most types of corporations. And when I say most types, I'm talking about what they call a C corporation. A C corporation is the standard sort of plain vanilla corporation that when you file to form a corporation, you start out as a C corporation, which really means nothing more than a standard regular corporation. In those C corporations, you can have any number of shareholders. So you can have 2 of you if you start the business. You can have 100 of you if you decide to take on investors and bring on other co-founders as your business grows. There's no restriction on the type of shareholders you can have. You can have individuals as owners of your business. You can have other entities as owners of your business. Shareholders can be in the United States. Shareholders can be in foreign countries. So you can have a co-founder down in South America if that's who you're working with. C corporations allow for all of that. So C corporations, good liability protection, lots of flexibility around the type of shareholders you have. So C corporations work pretty well. There is a drawback with C corporations. And again, we're not going to get too deeply into taxes in this talk for all sorts of reasons. One of them being that I don't want to get too deeply into it. It's not what I focus on. But it is important to know a little bit about taxes as it relates to choice of entity, what the right choice is. Some of you may have heard the term double taxation before. And what double taxation means, when you form a C corporation, the IRS looks at that C corporation as a person, like a fictional person. You created this legal person. And just like you as an individual person, you have to pay your taxes each year based on money that you make during the year. Corporations have to do the same thing. They have to pay money on the taxes they make, just like a person would. So that's one tax that a corporation pays. But let's say that the corporation has a good year and makes lots of money. And at the end of the year, the corporation is deciding what to do with all the money it made. And so let's say one of the things it might decide is it might decide that I don't need all this money. I'm sitting on all this money. I'm going to give some of this money back to my owners, my stockholders. Let them use the money, right? I don't need it all. So that's called declaring a dividend. So the corporation gives money to its owners. The IRS taxes that dividend as well. So when corporations give money back to the stockholders, that's also taxable. So that's a second tax, hence double taxation. The corporation pays tax once, and then if it distributes or declares a dividend and gives money to its owners, that's a second tax on the same dollar that the corporation made. So I don't know much about taxes, but I do know that we'd rather not pay taxes 2 times. We'd rather pay tax 1 time, single taxation. So how do we get away from this double taxation issue that some C corporations face? Well, there's another type of corporation called an S corporation rather than a C corporation. An S corporation is the same thing as a C corporation. You form it by filing the same document, Secretary of State. The difference is you make a second filing with the Internal Revenue Service. You do what's called making an S election. And when you make that S election, you now become an S corporation. That filing changes you from a C to an S. So who cares? What's the difference between S and C? There's a couple differences. When we become an S corporation, we get rid of that tax issue that we just talked about. When you become an S corporation, the IRS now, when they look at your corporation, they disregard it. You become what's called a disregarded entity. They don't consider you a person anymore for purposes of paying taxes. They don't tax for the most part. There's some exceptions, like there always are. But by and large, the IRS will not tax an S corporation on their profits. They will only tax the individuals, the owners of the S corporation based on those profits, which is 1 tax, rather than the C corporation where there may be 2 taxes paid. So S corporations sort of got rid of that double taxation issue. So you might be asking yourselves, well, okay, now you're getting the liability protection in an S corporation. and you're only paying one layer of taxes, why ever think about any other type of entity? S corporations sound perfect. Alas, it's not the case. It's always a little more complicated than that. S corporations, in return for getting that tax benefit, impose all sorts of rules on our shareholders. Right, in a C corporation, I mentioned there was flexibility. In an S corporation, you can't have more than 100 shareholders. Now, for most businesses, maybe that doesn't matter. Most early stage businesses, it might just be you and a few other folks. But there's other rules. You can't have entities as shareholders, only individuals as shareholders. That's another rule. You can't have anyone that's not a US national. So if you're going to have a co-founder that's located in a different country, they can't be owners of S corporations. S corporations can only issue one class of stock. You can't kind of create different types of equity to issue to investors. So if you're going to have outside investment in your business, an S corporation may not work because you're not allowed to issue those types of interests, what they call preferred stock. You can't issue that in an S corporation. So S corporations work really well so long as you can meet all of the rules that are imposed by the IRS to be an S corporation, which leads us to the third type of structure, the limited liability company. The limited liability company was invented 40 or so years ago out west. I think it was in Wyoming, if I'm not mistaken, which is odd because there's not that many businesses formed in Wyoming. And they basically said, we're going to take the best of both worlds. We're going to take the best of a C corporation and the best of an S corporation, and we're going to marry the two into a new type of entity called a limited liability company, or LLC. And LLCs have become very popular over the years for that reason. With an LLC, you get the liability protection, you get that shield being built around you, so that's a good thing. You also have no restrictions on the types of equity holders, the folks that own your business, what they call members in an LLC. You can have 2 of them, you can have 1,000 of them. They can be based anywhere. They can be entities or they can be individuals. You can issue different types of equity if you're going to take in investments. You have total flexibility, and it's a single layer of taxation rather than double taxation. So what they call a disregarded entity or a flow-through entity. Only the owners pay tax once. The entity itself will be disregarded by the IRS and won't have to pay tax separately. So it's a little bit more tax efficient. So LLCs have become a very popular choice for these reasons. I'll mention briefly, if the plan for your business is to get investment, big dollar investment from like professional investors, like venture capital type investors, in those situations, for a variety of reasons, and we won't get into all those reasons here, sometimes those types of investors, those professional investors, will only invest into C corporations. They have rules around the types of entities they can invest in, and they may limit their investment to C corporations. So if yours was a business that was going to be raising lots of money from outside investors, then you might be a C corporation because you sort of need to be a C corporation. But most businesses aren't going to raise that kind of money. Most entrepreneurial businesses, you're funding it yourself. Maybe some folks you know might give you a few bucks to help fund your business. That's how most entrepreneurial ventures get started. And in that case, an LLC is perfectly reasonable and often a very popular choice. I'll tell you this, we get this question all the time. Can we switch from one type of entity to another? Let's say we start with one choice and we make that filing with the Secretary of State. And then a year later, we decide, you know what? I think we want to be a different type of entity. And the answer is yes, you can switch. Going from being a limited liability company or LLC to a C corporation, let's say, is very easy. In most states, there's something called a statutory conversion, which is just another filing you make with the Secretary of State. And you basically convert and say, I'm an LLC. I want to be a C corporation. Here's my filing. Here's a few dollars. Boom, done. You switch and you become a corporation. Takes a couple of days. Going from being a corporation to an LLC is a little trickier. Sometimes there's, let's just say, adverse tax consequences. You might end up owing some taxes. It's a little harder to go from being a corporation to an LLC. So what we'll often tell clients who are asking us this question is, yeah, you know what, maybe you can start as a limited liability company, get the benefit of the taxes, the reduced taxes, get the benefit of the flexibility in an LLC, and start that way. And there's a good chance that you'll be able to remain a limited liability company for the lifespan of your business all the way through. If you run it for 30 or 40 years and just make money from it, or you grow it and you sell it to somebody down the road, maybe you can remain an LLC the whole time. And if you ever need to become a corporation, let's say you grow and you're going to raise money from a professional type investor, some sort of investment fund. In that case, if you need to be a C corporation, do a statutory conversion, and you can convert at that time into being a C corporation. So LLC to C corporation is a very popular sort of trajectory for lots of businesses. Others will remain an LLC for the lifespan of their business. I'll mention briefly, and then I want to get to questions. So if you've got them, throw them at me. Again, we love questions. There are some sort of newfangled types of entities that you may have heard about as the world is changing. And one of them is what they call public benefit corporations. You may have heard the term B Corp, which is sort of a type of public benefit corporation. LC3s, again, we're not going to talk in detail about these, but for businesses where your purpose is not just to make money, if your purpose is also to sort of do good, as they say, and they define what do good means, you'll sometimes hear double bottom line or triple bottom line, meaning you're not only trying to make money on the bottom line of your financial statements, you're trying to do other good things. There are other structures out there like these public benefit corporations that you'd form, just like you'd form a corporation, which sort of allow you to focus on things besides making money. So you can make money, and that's good. You can make lots of money in these types of businesses, but you can also benefit the environment or benefit educational ventures, those types of things. So I mention them just so you're aware of them. If you're a business that sort of has a focus on doing good in addition to earning profit, you can take a look at some of these newer structures. There's other benefits that you may get by virtue of being one of these kind of new structures, which are sort of new on the marketplace. And with that, I'm going to stop. I could talk forever, but that wouldn't be interesting for any of you, and I'd get cut off at some point. So we've talked about the why, the when, the how, the where, and the what in the world of entities and entrepreneurial ventures. And I'd love to hear questions on any of them. And I see in the chat, I'm going to click on it now. And I see business licensing assistance. That's important. Okay, so I see it from my first question here. In a multiple member LLC, do you need to issue a Schedule Ks each year, or is that for an S Corp only? So that's a great question. It's a tax question. As I mentioned, I'm scared of tax questions, but this one I'll take. And this is an important point. In these types of entities like limited liability companies or S corporations, where you're getting the tax benefit, there's, and you often work with an accountant to do this, but there's a document which is created at the end of each year in connection with you filing your own tax returns as an individual. And it's called a K1, Schedule K1. In S corporations and in LLC. So to answer the question from Donna, and in LLCs, your accountant, or if you're sophisticated from an accounting perspective or a tax perspective, you may create them yourself. But there's a Schedule K1 that you'll get at the end of each year. And then when you file your own personal taxes, you include that K1 to show what profits, how much money is being allocated to you as an owner of the business. So it's important to have a good accountant. I guess that's what I would say, or somebody who knows their way around taxes a little bit. I myself wouldn't know how to create a Schedule K1. It would be a little too complicated for me, but for most accountants, it's not complicated. You show them your LLC documents. They look at your numbers for the year, how much money you earned or how much money you lost for the year. And most accountants can pretty quickly create a Schedule K-1, which is what you'll need to file with your taxes. Hopefully, Donna, that answers your question. If not, feel free to bother me further. Not bother, that's the wrong word. So I see another question here. What is the classification that I could research to the do-good company, as that is what I'm trying to do? I assume this is not a 501c3 not-for-profits. That's a great question. So we didn't talk about not-for-profits. That's sort of a unique animal in the world of entity creation. So not-for-profits are just that. They're not-for-profit. So if one of the missions of your business is to make money in addition to doing good, not-for-profits are generally not the right choice. You don't have shareholders in a not-for-profit. You're not growing the value of your business. There's no implicit value in a not-for-profit. And with not-for-profits, there's a series of filings you make. There's a filing you make to form your entity, and then there's a filing you make to sort of get 501c3 status. And so you're right. What I'm talking about is something different, not a 501c3. And you can look up, you can sort of look up online public benefit corporations and sort of what you need to, kind of some of the things you need to be doing or some of the categories you need to be focused on. And a lot of them are not so different than 501c3s when you think about what doing good means. There's a distinction I'll make because people sometimes get confused. So you'll hear the term public benefit corporation, and that's what you file with the Secretary of State when you're going to do good. There's a step sort of beyond being a public benefit corporation. And that's called B Corp status. And sometimes people mix the two together. B Corps, there's actually a private organization that gives the stamp of a B Corp. So if you become a public benefit corporation and you want to go even further to really show that you're doing good, you can apply to become a B Corp with this private organization. They've got like 20 or 30 things they look at. It's actually tough. A lot of companies get rejected and have to go back to the drawing board and reapply in the future. When you become a B Corp, that means you're really focused on doing good and that you've been certified as doing good, whatever good means, by this private organization. So that's a second step that you don't have to do if you're going to be a public benefit corporation. But you can look online, whether it's educational, environmental, there's lots of different ways you can be a public benefit corporation. There's a fair bit of flexibility to become a public benefit corporation. If you want to take that next step and get that stamp, that B Corp stamp from the private organization, then you've really got to sort of fit neatly within one of their windows. But these entities are becoming more popular. Again, if you went back a decade, you wouldn't have seen any of these entities. So that's that. I see a question here from Timothy. If I establish my LLC in Illinois, can I upgrade to an S Corp in another state like Delaware, or do I have to remain in Illinois? That's a great question. It used to be a headache to move, to like migrate from one state to another. And by headache, I mean you really needed to hire a lawyer and create an entity in the other state, and then like do this mini transaction where you would like merge your entity into the other entity, and there were lots of documents, and it was almost enough work and expense that you never would do it. But alas, that's not the case anymore. It's gotten much easier. So I mentioned statutory conversion. So I could go from being one form like an LLC to a corporation. The beauty of that conversion is you're not limited to one state anymore. It used to be that like you could do it in Illinois. Now I can, from Illinois, file a statutory conversion document in Illinois and Delaware, and I can convert into a Delaware entity, just like I can convert into an Illinois entity. It's not that expensive. It's not that complicated. The forms are available online in both Illinois and Delaware, in your example, if those are the two states. And I can tell you that we have clients in our center that we work with that do this all the time. They'll start as an Illinois LLC, and for some reason they need to become, whether it's an S Corp or a C Corp, and they'll convert. And sometimes they need to move to a different state. You as a founder might move. Let's say you moved from Illinois to Wisconsin, and you decide, I want to take my business with me. It's less expensive if I'm formed up there, so I'm not having to file each year in two different states. You can convert. So moving from one state to another has gotten much, much easier over the years. So yes, you can. Let's see. So I see in Q&A some questions. So where does a nonprofit? So that's a question from Ziamia. So I mentioned that before, so I might have sort of touched on this before. The not-for-profit 501c3, you're forming an entity, but it's an entirely different process. Again, there's no shareholders. There's all sorts of rules around how you compensate people within those entities. You're not in it to make money. Now you can pay money. You can earn money and pay the folks that work for the not-for-profit. But if you have dual goals, if you want to make money, one, do good, two, then these hybrid structures are probably what you're looking at, public benefit corporations, things of that nature. I have a question here from an anonymous attendee. I have an LLC in Illinois, and I'm moving to New Mexico for less than a year. Do I need to refile an LLC in New Mexico? Great question. So if you're only going for a year and you're going to come back to Illinois, you don't need to move your entity to New Mexico. You can leave your entity as an Illinois entity. And in fact, it's probably easier to do that. There's a process in every state called becoming authorized to do business in that state. And what that means is, let's say you're formed in Illinois, and let's say you move to New Mexico. And let's say you open an office there and actually start hiring people in New Mexico, which you can do. You can be formed in a different state from where you're operating. At some point, you're going to cross a threshold. And the state of New Mexico is going to deem you to be doing business in the state of New Mexico. And in that case, you wouldn't form your entity in New Mexico, but there's a different filing you make with the Secretary of State. They just want a little bit of money. And so you tell them, hey, look, I'm formed in Illinois, but I'm operating here. I'm going to become authorized to do business here because I'm required to. Here's a couple $100, but I can remain an Illinois entity. And then when you move back to Illinois, you can allow your New Mexico authorization to do business filing to just lapse and sort of drift off into the distance. You may not even need to file anything like that in New Mexico. If you're going to be there for a year and you're not hiring people, you're not taking out office space there, every state has its own set of rules. And I don't know the rules in New Mexico, but there's a reasonable chance that they won't require you to do anything. And maybe you just leave your entity in Illinois, live there for a year, come back to Illinois. You didn't have to change anything. But at a very high level, you can certainly leave your entity in Illinois when you go to New Mexico. I see a question here with Diane Jones. Isn't an S Corp an IRS election and not a state entity election? Yeah, that's a great distinction, Diane. You're right. You form the entity with the Secretary of State. So that's a state election. When you decide to become an S corporation, that S election filing that I referenced earlier, that's with the IRS. So you're still a state entity. You've still formed in the state, and you were a C corporation when you formed. But once you make that S election with the IRS, which you're right, it's a national election, then you become an S corporation, even though you're still formed in Illinois and you're still an Illinois entity. So, so yes, that's exactly right. The S election is with the IRS, and it's not that complicated. The S election itself, if you wanted to go from being a C corporation to an S corporation, even that election is only a couple of pages. It's not that big of a deal if you wanted to make that switch. So I think hopefully that answers your question. And I think we are through to the end. I wanted to mention one thing to you. I've mentioned our center, the Donald Pritzker Entrepreneurship Law Center. So in that center, it's myself and two colleagues, Esther Barron, who often presents with me at these presentations, and Steve Reed. So we're all sort of similar to each other. We're all folks that have practiced law, that are now sort of professors at Northwestern, interested in entrepreneurship. And that's who's in our center. The reason I mention that to you is one of the things we do in our center is the three of us oversee students as part of a class. It's called Clinic, Entrepreneurship Law Clinic. And those students do legal work for early stage startup businesses, entrepreneurs across the city of Chicago, both inside and outside of the city of Chicago. We take real clients. So we work with businesses, probably like many of yours, What do we do? Well, we'll help protect your trademarks. We'll help with forming an entity. These things that we're talking about here today will help with that. We'll help draft a contract. So I mention this to you because if you've got a business, and I suspect most of you do, that's why you're listening to this talk, or you're interested in starting a business, feel free to apply to the Donald Pritzker Entrepreneurship Law Center. If you search Donald Pritzker Entrepreneurship Law Center, apply to be a client, you'll go to our website, and there's a page on our website where you fill out a very simple application. We can't take everybody that applies because we've got a limited number of students and faculty members. So unfortunately, we're limited in our bandwidth. But we love to work with early stage businesses across the city of Chicago. We've had clients apply from talks like this before, and we have lots of fun working with clients that find us this way. So if you, and one of the benefits of working with us is we charge either nothing or close to nothing. So we're very cost effective. So we can't promise we'll accept you because we get more applications than we know what to do with. But if you do want to work with us, please do submit an application. And in your application, let us know that you attended this talk. I like to know sort of how folks found us. So you can just say that, hey, you participated with the city of Chicago in this presentation. We do it twice a year. So we take clients in the fall, so in a couple of months. School starts end of August, beginning of September. So we'll take a batch of clients then. And then we take clients sort of for second semester, early January for that semester. And then over the summer, we don't have clients, we're off. But you can feel free to apply if you're so inclined. So I wanted to mention that because we'd love to work with some of you. And I see one other question, two other questions actually, which I'm going to try to get to quickly before I bid you farewell. From James, what happens if I want to do business in multiple states, like for real estate? Good question. So James, you'd form in one state. You can only form an entity in one state. So if you're based here in Illinois, then you might form your entity here in Illinois. But if you're buying a property, let's say, buying real estate in Iowa, as I mentioned earlier to one of the earlier questions, what you might do is become authorized to do business in Iowa. So you'd go to the Iowa Secretary of State website. You'd find their form to becoming authorized to do business. You can probably do it online. And so you'd be formed in Illinois, so you're an Illinois entity, but you can be authorized to do business in many different states. If you're owning real estate in those states, you probably do meet the test, and you probably should become authorized to do business in those states. If you're just, let's say you have like a salesperson that's based in just across the border in Indiana, you're based in Illinois, then you might, and they're working from their home. In that case, you may not be doing enough to have to become authorized to do business. In that case, you may just be an Illinois entity, and you might not have any other state filings. So it's a very state-specific test. The rules vary from state to state, as they often do, which is always frustrating. But for owning real estate, yeah, you'd form in one state and probably file in other states. And Donna, I see a question, Etsy, a company like Etsy or Amazon or other marketplace facilitator, do they consider all the participants selling as part of the company? That's a good question. So, a company like Etsy, I'm guessing is formed in Delaware. A lot of those big companies that have raised lots of money over the years tend to be Delaware C corporations. For some of the reasons we talked about, Delaware is kind of the fallback state when you're located all over the place. So a company like Etsy, let's assume they're a Delaware corporation. I don't know that for certain, but let's just assume they are. If they've got folks using their platform that are based in different states, that often is not going to be enough to require them to become authorized to do business. But a company as big as Etsy probably has offices all over the place, right? I'm guessing Etsy has New York offices and Florida offices, and they probably have something here in Chicago or around Chicago. If they don't, they probably will soon. So those companies often do have filings in multiple states, not because their users are based in those states typically, but because they have their own employees and office space and assets that they may own in those states. So for that reason, they're going to be probably in multiple states. But if you have a platform and other folks are just using it from North Dakota, that's not enough for you to have to become authorized to do business in North Dakota typically. I see another question here from Nicole. Can a profit change status to public benefit? You can change status. It's not quite as simple. The conversion, these statutory conversions that I've been mentioning, those were created really before public benefit corporations and these new what they call hybrid structures, mixed between profit and doing good, were created. So the answer is yes, you can go from one to the other, but there may be a few more hoops to jump through. And you may want to work with a lawyer that is sort of specialized with these types of entities to sort of help you navigate it. You may be able to do it yourself, but it gets a little bit more complicated. And with that, I think we're at time, maybe even a touch over time, I hope not. But thank you for all the questions. Again, look up Donald Pritzker Entrepreneurship Law Center to apply to be a client. And I hope to see you all around the business community, growing your businesses in Chicago.
Aaron, thank you so much. Tons of thank yous, very informative. This was great. We had someone say this is the best breakdown we've ever heard. And I agree, it was great. So we appreciate your time. I hope everyone has a great, safe, and wonderful weekend. Thank you.
Bye-bye, everyone. Thanks.